We've got our legal issues panel, and we're going to do it a little bit different this year. We've been kind of tweaking the format for a while, and we're treating this one a little bit more like a lightning round. So we've got 4 attorneys who have been kind enough to agree to be here to provide some updates on some kind of timely legal issues, and I've asked them each to spend 15 minutes up here at the podium covering that topic before we move on to the next attorney. So we're going to have Monique Norman of Monique Norman Law talking about an update on significant holdings and issues in recent decisions, as well as ongoing disputes. Then we're going to have Natasha Martin, a shareholder at Graves, Dougherty, Hearon, and Moody, talking about administrative penalties and enforcement issues, followed by Cole Ruiz at the Lloyd Gosselink law firm, talking about the viability of using federal courts in litigation against GCDs. And then we're going to close with Kimberly Kelley with the Bickerstaff law firm, who's going to talk about some federal cases potentially affecting the state regulation of groundwater. So I'm going to ask those 4 speakers if they could make their way to the stage and take seats here, and then they'll come up to the podium one at a time. Let's give them a warm welcome.
Hi, everybody. I'm Monique Norman. Have practiced water law for 25-ish years, and since '03, exclusively represent groundwater districts as general counsel, only represent groundwater district side, do not represent the applicant protestant side. Okay, so I was asked to cover 4 cases, which is a lot in 15 minutes. So I'm going to be flying through them and trying to focus on how they affect groundwater districts as a whole and not really on the weeds of the issue of the specific cases, although they're all kind of weedy. The first one is a prototype. Where do we go? Okay, prototype machine company v. Boulware. This is Kenny County case. I'm sure Kenny County feels like whack-a-mole, and hopefully this is the last one that they have to deal with, rising out of litigation, starting on protesting permits from '05. But the main issue on this one, the holding of the Court of Appeals on this that just came out at the end of July, is that this was dealt with a late intervener. There were some other ones, but prototype was the last one left. And the court in 36 says this as well. The court said you have to exhaust administrative state remedies in state court, and we'll talk about that issue later. This is state court, not federal court. And so that means that only the permit applicant, the people that contest the permit from the very beginning, and the district can be parties to the contested case hearing and therefore appeal to, in litigation, those issues. Not late interveners or interveners. Interveners are third parties that enter the civil suit late. And so that doesn't work. So for groundwater districts, what you need to look at is make sure is this echoing? Sorry. Make sure that your rules really incorporate these exhaustion of administrative remedies of subchapter M in your rules, and you put out all of those requirements of when does the protestant have to submit their protest. A lot of my clients I advise we do to recognize the 10-day hearing. We require the protest by 5 p.m. the day before the hearing, so at least we go into the hearing knowing what's going to happen at that hearing, whether it's going to be contested or not, but it still respects the 10-day hearing requirement, notice requirement. Make sure your rules cover all those exhaustion of remedies when you have to file a motion for a hearing and comply with Chapter 36 and all those issues. For the permit applicants and protestants, make sure you follow the rules. If you don't meet those deadlines, you may not be able to contest. You will not be able to then challenge it later as prototype. The other issue that a lot of this, I think there was 4 different appeals. Various people were chasing attorney's fees. Of course, when you chase attorney fees, you create more attorney fees. And so the other issues, the appellate court said the trial court under Chapter 36 and the Uniform Declaratory Judgment Act have broad discretion in issuing attorney's fees, and when it's in the interest of justice, which was one of the issues that they were contesting. Okay, so those are those issues. Sorry, I'm not multitasking very well. Not that one. Okay, Quadvest. Okay, this issue does not involve a groundwater district, although it comes out of litigation with the Lone Star District when Quadvest and other investor-owned utilities challenged the Lone Star District's groundwater reduction plan rule. That was later settled and agreed and put into final judgment that invalidated that groundwater production rule. But those large volume groundwater users had, because of that rule, had entered into joint groundwater reduction plan contracts with the San Jacinto River Authority. That's what this case is. They sued, they want out, the investor-owned utilities want out of those contracts. They're using groundwater, they're not even using river water. The first thing that SGRA did, well, not the first thing, but what they did is they filed a motion to dismiss. One of the issues was that it was on an interlocutory appeal, the issue of state action immunity. And the court, the Fifth Circuit, so two things. After reading this opinion, the Fifth Circuit is the only circuit that lets you do state action immunity issues on interlocutory appeal. So that's an interesting issue. The other issue is they went to the meat and potatoes of does SGRA enjoy state action immunity? And the Fifth Circuit said no, they don't, because they went through the different analysis, the different tiers of it, and they said although they do have legislative authority to do these contracts and set rates and go into contracts, the legislature had to specifically said that it was allowing them to go into competitive in the markets because this is a Sherman I'm sorry, I skipped over that very important issue. They're suing federal court under Sherman Antitrust Act, price fixing. And so the legislature would have specifically allowed them to do that, and the Fifth Circuit said they don't. So this was the beginning of August, sent back to federal court for the case to begin. Sorry, I feel like I'm flying through on this. I'm sorry if I'm talking fast. Okay. The next one is, now we're in federal court on Fazzino v. Brazos Valley. Full disclosure, I've been general counsel for Brazos Valley for 20-ish years. So I'm going to try to stay very broad on this case. This issue comes out of, based on, I understand the Brazos Valley's rules. They were first in place in December 2004. They established existing and new rules based on the adoption date of the rules of December 2004. You're an existing well if the well was drilled or you had significant development of that well. And if you didn't have those things, you're a new well. That's a basis of this lawsuit, in that they filed a equal protection claim and a takings claim based on that premise. Fazzino has approximately 26 acres. If he positioned the wells appropriately, or not appropriately, but in the right way, he could get up to 800-something acre feet on those 26 acres under the new permit rules, new well rules of the district. But he didn't want what he could get under the rules that apply to new wells. He wanted what the neighbor had that was an existing well, which was several thousand acre feet. So that's the basis of the lawsuit on a very simple version. It went through SOA, it went to state court, it was dismissed in state court, maybe on exhaustion of, didn't get to those issues, but maybe on exhaustion of state remedies, went to federal court. We talked earlier about the Kenny County prototype Boulware case about you have to exhaust administrative remedies. Well, that was an interesting first issue in this Fazzino case. Is in federal court, they first dismissed on that Williamson County case, you have to exhaust administrative remedies. While it was waiting at the Fifth Circuit, the Supreme Court changed. They overturned Williamson County, and so now at federal court, you do not have to exhaust your administrative remedy. Oh my gosh, 5 minutes. Okay, so really quickly. So last week, the federal judge ruled in favor of the Brazos Valley Groundwater District for the equal protection only. The takings claim is left. They went through the analysis why the well next door, the City of Bryan Well 18, is not a similar, they are an existing well, and there's a rational basis for those rules, and I'm rushing through that. The takings claim is still pending, so that will be, I think, trial is set for November at this point, and there's still a pending motion for summary judgment. So we're still waiting on whether we have court or a ruling on that issue. The next one is the last one, and a few minutes is not enough to talk about the LCRA permit to Lost Pines. LCRA permit for 25,000 acre feet on about 4,800-ish acres. That issue has several protestants. It's gone to contested case hearing. The SOA, the ALJs, has issued their proposals for decisions, and there are three primarily recommendations on those. Two, that LCRA and Lost Pines must enter into a monitoring well agreement to assess impacts caused by production from the LCRA well field. LCRA is required to perform a pump test as they drill each well in the district, and the GM may adjust the rate of withdrawal if necessary. Also that the total permit amount is phased over 4 phases, up to a maximum of 2,500 acre feet at 8,000 GPM. LCRA must meet several conditions before advancing through each phase, including providing binding commitments to show actual demand for the additional groundwater. These are agreed provisions between staff and LCRA. The Lost Pines Board has not yet issued a final ruling on that. They've had a series of hearings, and I've told that maybe in September they're going to issue a final ruling on that. I am not involved in that case. There's several issues related to that. I know there's some questions about the PFD says that Bed and Banks permit is not waste based on Corpus Christi Pleasanton case. I think there's some questions about that because after that 1955 case, the water code was amended, the waste definition was amended. It says that it's not waste if you put groundwater in a water course if you have a Chapter 26 permit, which is TPDS water quality permit. Bed and Banks permit is Chapter 11 permit. So there's some questions about that. Is that really the law? And you would need a Bed and Banks and a TPDS permit for it not to be considered waste, potentially. So that's an issue. There's also issues how it affects groundwater districts when you've got these agreed amendments and the part in Chapter 36 where it says that, I'm thinking 113, that you can put restrictions in a permit, but then it has to apply to all new permits and increased use by historic users after that time, after you put that restriction in. Well, does that apply to settlements? How does that affect future permits in the district? It's an interesting question that I think we need to watch and affect all of us. And the other issue is that again, I don't have anything to do with Lost Pines and LCRA. I am in GMA. I represent 2 clients in the same GMA as them. Their permits, predictability in rulemaking and production acreage requirements, and Lost Pines rule doesn't have a typical production acreage requirement. Are we down to 1 minute? Like a 2 acre foot per acre foot. So that's why you have a 25,000 acre foot permit on less than 5,000 acres. And if districts or other districts, I always preach to my clients about putting predictability in your permits. Your discretion of the board should be in developing your rules. And then the applicants know what they get in their rules and in their permits, and it really lessens litigation a lot when they do that. So, imagine if Lost Pines had a 2 acre foot per acre, or I'm just pulling that out of the air, or 1 acre foot per acre, then the applicants would know if I have 4,800 acre feet, I would get 48 acre feet per acre per year. And that predictability manages expectations and really limits litigation quite a bit. Am I close? Perfect. I really rushed through a lot of points that I'd like to go and discuss a lot more. If anybody wants to talk about it, I'm a total policy wonk and would love to talk about it.
You definitely put the lightning round. That was great. Thank you.
I hope it's okay. I just jumped up here.
Exactly right.
Okay.
I'm sorry. I did not multitask.
It's okay.
Well.
You're fine.
Do you want me to do it for you?
No, it's good. Oh, wait, here we go. All right. Okay, so thank you to Leah and Tagged for having us here today. I'm especially excited because our firm just joined as an associate member. So the Aggie and me would say, whoop. Are there any others? There's a few. There we go. So we're going to talk about enforcement. You'll hear kind of a district flavor tone as I represent Lost Pines, but as a landowner and an applicant, all of these kind of methods and tools you should track as well. Okay, so we'll talk about the authority and, which statutes that districts have authority to regulate from and enforce from. We'll talk about which powers come from those authorities, and then also enforcement considerations, and then a few cases, and notably the Mountain Pure case, which is pending right now, if the district loses, could have significant implications on all of this enforcement program that districts have authority to do. Okay, so I didn't start my timer. There we go. So kind of the broad authority comes from the authority to make and enforce rules. And so you'll have a district that has adopted an enforcement program within their rules. The key provision here, though, is 36102, and that allows districts to sue any person for civil penalties in district court. Those are your two Chapter 36 provisions. We'll talk in more detail about 102 later. But then you also have the district's enabling legislation. Those typically have a provision that allows a right to enter and inspect, gather evidence, determine if there is in fact a violation of a district rule, a permit, or even a state law. And then lastly, also outside of 36, you've got your rules, and those rules typically adopt an enforcement program. Okay, so we'll talk about inspections. So, the first big consideration with the inspection would be whether the inspection is considered an administrative search. And so under 36, districts inspect property to determine if there has in fact been a violation. And so the thing about this administrative search, which it is termed that in the statute, it has to be reasonable. And so that comes from constitutional law, whereby, you can't have an invasion of privacy. There has to actually be a foundation or a basis, a rational basis for the search. What Chapter 36 does to kind of address this reasonableness standard is that it requires the districts to give like a notice that they are present on the property. Some districts have taken that further, and I think it's a best practice to gain the consent from the landowner before going out there. Some of their rules even add that additional layer, but really the statute just says you have to tell them that you're there. You have to follow safety measures and fire protection, et cetera, when you're out there. So there's more about the reasonableness standard, but I don't talk as fast as Monique. So look at the U.S. Supreme Court case on the Fourth Amendment searches, Camara. That's going to give you a 3-part test on what's reasonable or not. And the big part of that 3-part test is your search authorized by a statute? And so here it is. Here this search would be, so, kind of default, it is reasonable. But look at that case if you want more. So another provision that we often don't think about is the authority to inspect under Chapter 26 of the Water Code. That's 26.173. And that you're really inspecting for water quality conditions. Okay. Oh, we've got a nice picture. I love pictures. Okay, so abandoned or deteriorated wells are usually the source of many enforcement actions. And thanks to the EAA, we've got this pretty picture. On the left, you'll see a well that's been well maintained. On the right is a deteriorated well. Your primary concerns with these abandoned and deteriorated wells, you'll see in the photo on the right, you don't have that well cap. And so you can have contaminants come down into your well. Also, if your well casing is deteriorated, you can have leaching out of contaminants into the aquifer. And so the big thing here is going back to the charge of districts, protection of the aquifer, protection of groundwater. These abandoned and deteriorated wells threaten the aquifer. I mean, we've all probably heard of Bomber Lake. That is a lake that was created from a uncapped well, an unplugged well. And so that area is actually, there's some subsidence issues, but it's actually now sinking. You've got this bright green lake in the middle of nowhere. Most districts aren't going to have a well this severe, but that's just an example of how bad things could get. So Section 36.118 allows districts to close and cap wells if the landowner or well owner fails to do it, and then the district can put a lien on the property to recover their costs of doing so. You know, one thing I didn't put on here, and you should jot this down, Section 1901.256 of the Texas Occupations Code also applies here, and it requires GCDs to enforce the state law of the Department of Licensing and Regulation related to abandoned and deteriorated wells. So that's another authority, but it's really more of an obligation than an authority. That code provision also gives the authority for the district to go after that well owner in a civil suit. So just like 36, and we'll talk about 36 civil suits. Okay, so oftentimes, you know, districts do and should try to settle these violations outside of court. And so we call, you know, kind of informally, we call these pre-civil suit efforts. And you'll recall that districts have very broad authority for rulemaking and adoption. And so a lot of districts will kind of put this pre-civil suit attempt in their rules. So you'll see something like a notice of violation being sent. Hey, stop producing over your permitted limit. You'll see next an opportunity for that violator. I'll say violator because I'm with the district. A landowner might say alleged violator. But anyway, sometimes there'll be an opportunity to work with the district and just meet and confer about it. And that notice will also have, you know, a requirement to do some sort of corrective action. So if the person, you know, fails to meet with the district, fails to do the corrective action, you know, then you're kind of left with the civil suit option. But I mean, a lot of times these notices do work. And so what you'll get on the back end is you'll get a settlement agreement between the landowner, the district. Usually involves the corrective action and then also like payment of the district's costs to go after and try to seek compliance. But anyway, these agreements would need to be approved by your boards. Okay, so the lawsuit part, what we try to avoid. Oh, 5 minutes? Okay, that's a very different 5 minutes than I have. So now I'm down to 4 minutes. So if settlement's not an option, you've got, the district has district court opportunity. There's also even I sound like Monique now, a citizen suit opportunity. But we'll talk about that the citizen suit is a little rare. So under 36, going back to 36.102A, you know, districts can go to district court for civil penalties and injunctive relief. You're going to file that in the county with the district. Part of the statute says, you know, where the district office is actually positioned. You go to district court for these civil penalties, but the district first has to adopt the penalties in their rules. And that penalty can be up to $10,000 per day per violation. Those penalties then could be assessed by that district court. So most of these actions are taken care of at the district court level. Not many of them go up on appeal. But I should note that if the district prevails, the district can seek attorney's costs and fees. There are some kind of restrictions with seeking fees and costs from governmental entities. But you can't just charge them additional costs over the fees that you've set up in your rules. So we're going to move on. Okay, the citizen suits, this is not a commonly used mechanism, but you can really a citizen can only sue over 2 violations. That's if somebody's out there producing without a permit or they're exceeding the permit limit. In order to bring this suit, that citizen would have to be an adjacent landowner. They say, a landowner who has a right to produce. So, or a landowner that has a right to produce within half a mile of the violator. Before that citizen suit can be brought, though, they have to file a complaint with the district, and the district's got to determine, yes, one of these 2 items was actually violated, and the complainant has to actually wait 90 days before filing the suit. And I imagine that 90-day waiting period is so, the district is now on notice of an issue, and so the district could probably come in and maybe get compliance. Again, this is a rarely used provision, but it's out there. So this slide I put in here for Greg Ellis. And, there's an open question on whether districts can assess administrative penalties. And so these penalties would be penalties in addition to these civil penalties that we just talked about. And you wouldn't be necessarily going through the courts to assess this penalty. Some say that 36102C allows for these administrative penalties. C says that civil penalties are, quote, in addition to any other penalty provided by law of this state. So I haven't found that any other law. Some people have found it, pulled it out of their hat, but have not produced the citation for it. So anyway, there's no express authorization in 36. And I think that's an important point. It might be out there, but this is kind of a gray area. But not all districts are in this gray area. As you know, like Edwards Aquifer Authority, they have their own act. And under the EAA Act, they actually are expressly granted administrative penalty authority. Okay. Is that 1 minute? That's 1 minute. 90 seconds. Okay. So the case that I was saying that could really kind of I don't want to say blow it up, but it could be really bad if the Natchez and Trinity Valley GCD does not prevail. So really quickly, Mountain Pure owns basically a bottling plant. They had a tenant that was actually doing the bottling and the operations. They were getting this water out of an excavated spring. Sounds like a well, but anyway, the district said that's a well and it's regulated. So you need a permit. They sent a notice, kind of like the notice we just talked about. You need a permit. Mountain Pure, they said whatever. They never applied for a permit. So rightly so, the district goes ahead and files this enforcement lawsuit. So the lower court basically, let me see. The lower court threw out they threw out a contracts claim. So basically, Mountain Pure said, hey, you've tortiously interfered with my contract because my bottler ran away because they were scared from your lawsuit. And so anyway, lower court said, we're going to throw that out. But Mountain Pure also brought a takings claim, which was not thrown out. The Court of Appeals threw out the takings claim because they said there's no evidence to support that there's a total regulatory taking. So to show a total regulatory taking, there'd be either a physical invasion or a regulatory invasion. And the big issue is filing a lawsuit. Is that an actual taking? There's a court case, City of Houston v. Carlson, that says no, you can seek enforcement, but that is actually not an attack of the rule or statute. And Mountain Pure has failed to actually attack the rule or statute. So that's an interesting one. Let's watch it. Rolling Plains deals with immunity, and I'm wrapping up right now. And we're on to Kimberly or Cole. Okay. All right. Thank you all. Okay. Here we go.
Good morning, everybody. thank you for allowing me the opportunity to come and speak to you about this. And compliments to Leah for putting on a great Groundwater Summit. My name is Cole Ruiz. I'm with the Lloyd Gosselink law firm, and I'm talking to you today about federal courts litigation, specifically from the perspective of a defendant if you're a groundwater conservation district. I think that following up with the presentation that we just heard on the enforcement aspect of it, this is more of that defensive side. So let's go ahead and get started. So the first question we want to talk about when we're trying to access a federal court is jurisdiction. And jurisdiction is generally speaking, a court's authority to hear a case and to oversee that case and make a judgment on that case. As groundwater conservation districts, you have some sort of quasi-judicial authority as prescribed by Chapter 36 of the Texas Water Code. State courts are generally, they have what's called general jurisdiction, so they can also hear those types of cases that groundwater conservation districts hear if there's a contested case over a permit, for instance. Can you hear me? All right, good. Sorry about that. And so when we're talking about general jurisdiction, we're talking about state claims that are put in the Texas Water Code, but also claims that are brought under federal statute. So state courts do have authority to hear federal claims. When we're talking about federal jurisdiction, federal courts have what's called limited jurisdiction. And there's several ways to get into federal court if you're a landowner, for instance, trying to sue a GCD. And that's going to come under, if you're plaintiffs of different, or if there's one party is in one state and the other party is in another state, that's called diversity jurisdiction. That's not really applicable to GCDs because all GCDs are in the state of Texas. But really what we're talking about for GCDs from their perspective is what's called federal question jurisdiction. And so I'm not ashamed to admit that before I prepared for this presentation that I pulled my old civil procedure textbook off the old shelf there, dusted it off, and opened up to understand exactly what the intricacies of supplemental jurisdiction under the federal question are. There's a complex case law on it, but it's been pretty well settled that if you have a federal question, a lawsuit that's arising under a federal question, such as, say, a takings or an equal protection action, then that court also has jurisdiction to hear the state claims. So typically, if there is a question that's arising under, if there's multiple questions, right, a federal question or something rising under state law, if it's in the interest of the landowner to seek to have a federal court look at that, they might opt to try to file in federal court. We kind of covered this a little bit through some of the other presentations, but I'll just kind of go through some of the ways to get to state and federal court. Under the Texas Water Code, Chapter 36066 and 36.251 are options to get to they basically give state courts jurisdiction. There's 36.102 is the enforcement action that was just spoken about in the last presentation. And then in federal court, a lot of these actions are going to come under either UDJA, Uniform Declaratory Judgment Act, where they're asking the court to declare what the rule, let's say a district's rule means, or an equal protection or takings claim, which would be filed under 42 USC 1983. And as I was saying earlier, to get into federal court, that claim has to come under a federal question. And to repeat myself, equal protection, takings, and declaratory judgments those are sort of the what we see the most when groundwater conservation districts are being sued. That's not an exhaustive list, but those are generally the cases. Federal court can hear state claims only if the federal claim and state claim form part of the same case or controversy. So in order to get supplemental jurisdiction, those claims have to arise out of the same facts. And there's a lot of case law on that, and a lot of litigation over that, but that's the general rule. And a federal court may decline the state claims. They might say, hey, we're not going to focus on the state claims. We're only going to look at the federal claims. And the reason for that is because the state law oftentimes might be dealing, especially with groundwater, with a novel or complex issue. So they are not necessarily required to hear the state claim. So just some examples. If somebody were to file a lawsuit under 36-251 on say, a decision that a groundwater conservation district makes, say the district were to deny or grant a permit of less than what was asked for, and not attach any federal claim, then there would be no federal claim, and so there's no federal jurisdiction. If, on the other hand, though, they attach a takings claim, for instance, then that grants the federal court jurisdiction. Okay, so some differences between state and federal court. I think I was asked to kind of go over this because there's been an ongoing conversation about the viability of, for groundwater conservation districts, or for landowners, frankly, to sue groundwater conservation districts in federal court. Does that improve their position? Does that, what are the differences there? So I'm going to go through a few of those. On the question of immunity, as you all probably know, directors enjoy immunity from official votes and actions. In federal court, they have what's called qualified immunity. Immune unless the director action is objectively unreasonable in light of the legal rules that were clearly established at the time of the action. So there is a narrow exception for immunity. As far as fee shifting goes, we've had a lot of talk about that at this summit so far. As you probably know, that if you're sued in state court, that attorney fee, the 36066 mandates that if the GCD wins, it prevails in that particular scenario, in that claim, that the judge will award attorney's fees. That's not the case in federal court generally. It depends on the federal claim. There are some claims where a federal judge has the authority, has the discretion to award fees under certain circumstances, and I'll cover those a little bit in the next couple of slides. One of the biggest questions, I think, from the GCD perspective is the cost of litigation. Generally speaking, federal litigation is just going to cost a lot more. There's more attorney work involved. There's more research and writing and briefing, and so federal court costs can get pretty high. And then timing, these are very general rules, so it could be different depending on what the intricacies of a case are, but generally speaking, federal court's a bit quicker process than going through state courts. So I'm going to spend a little bit of time on this particular slide. There are some perceptions out there of particular, say, benefits or cons to filing, say, in state court versus federal court. One perception in particular is that landowners won't have to pay GCD attorney fees. That's generally the case, but there are several statutes, including 42 U.S. 1983, which is where you're going to bring a takings or a equal protection claim under, that allow discretion to the judge to award fees to the prevailing party. But if the prevailing party is, in this case, a defendant, say a GCD defendant, the GCD would have to show in that type, and to be awarded attorney's fees, that the lawsuit was brought, or that particular claim was brought frivolously. GCDs don't enjoy 11th Amendment immunity. That perception, that's a correct perception. The Fifth Circuit ruled in the Brazos Valley case that the Brazos Valley GCD was not an arm of the state for that particular purpose under the 11th Amendment. And then, of course, the big one is the federal court is more likely to find that a Texas groundwater law, a GCD's rules, or a GCD action violates the Equal Protection or Takings Clause of the United States Constitution. That perception is only a perception. There's really no evidence to suggest that one court is more favorable than another. And so of course, the facts and circumstances of each case are going to determine that. Okay, so key points on federal jurisdiction of suits involving GCDs. Federal courts have jurisdiction over any claim arising under federal law. We covered that. Federal courts would only have supplemental jurisdiction over state claims. Bringing a state claim in federal court could complicate things. Yeah, so I put that in there because when you're a landowner and you're trying to figure out if you're going to sue a GCD in federal court or state court, you're really going to look and see, does this court have the qualifications or the experience to understand the novel complexities of the case? And since groundwater law tends to, the facts are always very different, in particular to whatever that resource is. It's very fact intensive, it's very science based, and so really you're going to ask yourself the question, is this court going to rule on just law and not look at these intricacies, or is a state court better equipped to do that? GCDs would still be entitled to attorney fees if they prevail in state claims in federal court. So if for instance, a federal court has supplemental jurisdiction over a state claim, if I'm representing a GCD, I'm thinking to myself, yeah, I'm going to make that argument to try to get those fees if there's a state claim that the court is ruling on. So it might be in the interest of the landowner to not engage state claim. So if it's too complicated to bring in that state claim, it might be in the best interest of the landowner to not bring it in at all and just focus on that takings or equal protection or Uniform Declaratory Judgment Act claim. Some other federal court considerations. Federal judges are not elected. Federal judges may be less familiar with the complexities of Texas groundwater law. We kind of discussed that a little bit. Attorney fees could be awarded to either party depending on the federal claim. But again, there's that exception that if the GCD is a defendant and they're trying to get attorney fees awarded, they're going to have to show that claim was brought frivolously. I'm not going to cover this because I'm running out of time, and I think we've already covered it throughout this summit. But essentially, it's this 36066 conversation at the legislature. SB 152 had that one provision that was trying to sort of quote unquote level the playing field between the GCD and the landowner with regard to attorney's fees. The reality is, I think that typically attorney's fees are an afterthought to the merits of a case. We're talking about this in order to level the playing field, so to speak, to give more access to landowners to the courts. I'm sure everyone's got an opinion on that, so I'm not going to dive into that too much. I think we've already covered this. Key takeaways. So can GCDs be sued in federal court? Yes, obviously. So long as that case arises under federal law. Federal courts are becoming more attractive for landowners because of these perceptions that we've talked about. But I'll reiterate the fact that these are perceptions. There is no evidence to suggest that landowner is more likely to prevail in federal court than state court. It is more difficult to recover attorney fees in federal court as a GCD, but generally you're going to enjoy the same defenses and authorities and such in state court as you would in federal court. The law does not change. And to go back to that 36.066, I think you heard Senator Perry earlier, that issue has not died. It sounds like he's going to bring that back next session. And so there'll be a continued debate over that bill and particularly the attorney fees issue. And if there's one thing I think I'll leave you with today is that if you're talking about cost of litigation, really the best way to defend yourself if you're a GCD is to equip yourself with a good insurance policy or risk pool, and that way you can be prepared to defend yourself in these court cases. So that's all I have.
Hello, I'm Kimberly Kelley. I know I am standing now between you and the end of the conference, so I appreciate being here today and talking to you a little bit about federal litigation of interest. So today I'm going to be talking about 3 cases here. These are federal cases in front of the Supreme Court of the United States that have the potential down the line to affect groundwater in Texas. These are in various stages of litigation, and some we expect will be litigated further. So as we went, we kind of got loftier. We're now at the United States Supreme Court, so the effects are less clear on groundwater in Texas, but we're going to talk about some overall themes and some issues to watch. So the first 2 cases here are Texas versus New Mexico and Mississippi versus Tennessee. Cole just touched on some jurisdictional issues. This is a different type of jurisdiction. This is original jurisdiction before the Supreme Court of the United States, which is kind of a unique thing, so I thought I would just do a brief overview of what that looks like. There are a couple of ways to get in front of the Supreme Court, and the normal way is to start at the lower courts for all of these cases and to move on up, and then the court will act as the final appellate review. But there's a different way, and that is when the Supreme Court has original jurisdiction. In that instance, they're acting as a trial court. That's only for particular cases. In this case, Texas versus New Mexico and Mississippi versus Tennessee, it's when 2 states want to file a claim against each other. There are also some instances if the United States is versus a state or other instances like that. But here, the Supreme Court is hearing this case for the first time. And the Supreme Court is really not set up to be a trial court, so what they do is they appoint a special master, and a special master essentially tries the case and then makes a recommendation to the Supreme Court, and they have the final ruling. Another little background here, what I'm talking about is interstate water courses, typically rivers, that are either flowing from one state into another or they act as a border for the states, but both states touch the river. So there's 3 basic ways to allocate those interstate water supplies that are shared by states. The first way is apportionment. It can be judicial apportionment or legislative apportionment, and the other is if you enter into a compact. So equitable apportionment is the Supreme Court basically telling you going forward how you're going to share the water. It's the equitable apportionment doctrine in the Supreme Court was established in the very early 1900s, and it's a remedy for when you get into a conflict with another state. Basically, one state will come and say, hey, we have this shared resource, we think this other state is taking too much, and we've been harmed by this. So Supreme Court, can you step in and decide how much water we're each entitled to going forward? And the Supreme Court will make that determination. The other way is if you want to enter into a compact with another state. And a lot of states have done this because they want a seat at the table and they want to be able to negotiate their own water rights with the other state rather than have the Supreme Court tell them what to do. So that's a more tailored approach. So what I'm going to do now, because time is short, I'm just going to go through the facts of Texas versus New Mexico and then the facts of Mississippi versus Tennessee, and then we're going to talk about kind of the combined effects that we can see on Texas groundwater. So the first is Texas versus New Mexico, and I know you've heard about a lot of these cases before because this one and the Mississippi case have both been here we're going on 8 years, I think, for both of them. But I'll give you a brief reminder on what Texas versus New Mexico is. In 1906, the United States entered into a treaty with Mexico to deliver a certain amount of water annually upon the completion of a dam in the Elephant Butte Reservoir in New Mexico, which was part of the Rio Grande project. Then in 1939, 3 states, New Mexico, Texas, and Colorado, entered into the Rio Grande Compact, which was approved then by Congress. And that's essentially an agreement that requires, in relevant part for this lawsuit, New Mexico to deliver water to that Elephant Butte Reservoir, which importantly is not on the border of New Mexico and Texas. So there's land in between in New Mexico before we get to the border. So what Texas is contending here is that New Mexico is improperly allowing groundwater and surface water diversions in between that delivery point in the reservoir and the border, which is decreasing the amount of water that Texas is actually receiving. We also have the United States has intervened. That's on the basis that the groundwater pumping in question also impacts its treaty with Mexico. And then we have the kind of local contention for the amicus parties, where it's the irrigation districts and the on-the-ground local entities in Texas and New Mexico. The other thing that's important here is the hydrogeology. So we have the Rio Grande River, and then under that is the Mesilla Bolson and the Hueco Bolson aquifer. Both of these aquifers are in different ways in New Mexico, Texas, and Mexico to just varying degrees. So we're talking about pumping within these aquifers that impact then that project. So with that in mind, New Mexico has also filed a counterclaim, and that counterclaim says, actually, you know what? Pumping in Texas on those aquifers is contributing to what they say is the loss in water. And then there's no claims by or against Colorado because they're north of this. So these are kind of the major rulings to date. I won't go through that, but I did just want to point out that the first phase of trial on this was supposed to be in September in a couple of weeks. They pushed that back a little bit, but we are looking to go before a special master in mid-October, so stay tuned on that one. The other one I want to talk about is Mississippi versus Tennessee. This case is a really interesting case. Essentially, Mississippi thinks that Tennessee is stealing its groundwater, and they want to be paid for that. So they don't actually, it's not actually an equitable apportionment case. I think it's more properly just not a compact case because Mississippi does not want the Supreme Court to equitably apportion this groundwater. They want damages for it, and they want it all. So this is it's the Middle Claiborne Aquifer, the Sparta Sands. It spans 8 different states, and it's underneath both Mississippi and Tennessee. But Mississippi's point here, so they brought a case against really the utility on the side of, in Tennessee, the Memphis utility, and then the city of Memphis and Tennessee. But really what Mississippi is contending is that they have a sub-aquifer that is underneath just Mississippi, that it's a part of this overall aquifer, and that aquifer is pretty well confined, and it has good groundwater, and it wouldn't be depleted for generations, but on the Tennessee side, they have massive pumping operations and high-tech pumps, and they're creating a cone of depression, and they're taking some of Mississippi's groundwater. So Mississippi does not want this to be apportioned between the 2 states. It just wants it all. So instead of the equitable apportionment claim, it has brought trespass and conversion claims, and it's seeking over $600 million from Tennessee. So Tennessee has said, whoa, whoa, whoa. This is not the way that we do this. They've said, 1, the aquifer is in fact a shared interstate resource and it should be equitably apportioned because that is the remedy that the Supreme Court has laid out when you have a shared resource like this. So it turns out the special master agrees with Tennessee here, and they went ahead and did an evidentiary hearing because when a special master takes a case, they try to make the record as clear as possible for the Supreme Court to review. But they did an evidentiary hearing, and they found that, in fact, this is a shared resource, evidenced by, lots of different reasons, but also because the fact that Tennessee can affect this aquifer means that it's probably connected in some way. So they have dismissed Mississippi with prejudice so that they can go and refile an equitable apportionment claim. This is also set to go to trial in October. So the U.S. Supreme Courts will hear oral arguments, so October is going to be an interesting month at the Supreme Court. What lessons can we take from this? Interstate litigation. Obviously, we can, if you're in the Mexico, 5 minutes, that does sneak up on you. Texas versus New Mexico case. That's going to affect El Paso, that's going to affect other pumpers in that actual area, but in a broader sense, there's an increasing number in these original jurisdiction cases before the Supreme Court as water gets more scarce, and it is increasingly involving groundwater. The date of these compacts in question for compact litigation is important because a lot of these were entered into in the 1930s through the 50s when they were really allocating surface water, and they recognized a connection between the surface water and the groundwater. But when we have these compact litigation cases, a big issue has been whether or not that compact takes into account the groundwater and to what extent. So that's been litigated a couple times, and when it's beneficial to a state to argue that, this is just surface water, it's not groundwater, it's never a defined term, the Supreme Court has really said, there is a connection between the groundwater and surface water. But the hydrogeology has been very important. So these cases have really turned into battles of the experts. It's not only a shared aquifer, but as we see by Mississippi, Tennessee, it's a subunit of a shared aquifer and how much that all matters. So that's been a huge part of these cases. Another part is the differing state groundwater laws. Some of this Supreme Court litigation over the years has led to legislative changes in various states. They either change because they've lost something. For instance, in 1945, Kansas essentially rewrote its water code because it had been involved in some compact litigation, and it had a river that it really wanted and didn't get the amount that it wanted, so it made some pretty big changes. More recently, in 2007, Nebraska made some tweaks to its water code in response to one of these cases. So it doesn't have to be a huge legislative change. It could be minor tweaks. It could be statewide. It could just affect a small area. There's a lot of unknowns there, but often these types of cases can be a vehicle for legislative change. And then lastly, equitable apportionment for a groundwater case only. So the Mississippi versus Tennessee, all of the other compact cases are involving, like for instance, the Rio Grande River, and we have the two aquifers that are under it. But Mississippi is just fighting over an aquifer. So equitable apportionment has not been applied just to the aquifer. And the interesting thing out of Mississippi and Tennessee is that if they do get dismissed and refile it, we could see that case come out. And the other interesting thing out of that is they tried to bring some really interesting claims and bring some damage claims, huge damage claims against another state. And I think that it looks like that's not going to fly. There were amicus parties. Most of the states that are in compacts all filed amicus briefs and said, we have the bounds here. We have compacts and we have equitable apportionment. And Mississippi is trying to get damages for something that Tennessee really doesn't have a duty to them, at least under the law as it is now. So that's an important piece in applying that to Texas, is that for a second there, it looked like there may be some unknown thing where you can just seek damages. Then lastly, in my maybe 2 minutes, that's plenty of time. So lastly, I'll just briefly touch on the County of Maui versus the Hawaii Wildlife Fund. This is a case that I believe you've heard about before in this conference, but the County of Maui's wastewater facility treated water. So they have treated effluent and they inject it into groundwater wells very close to the Pacific Ocean. So what happens is they didn't need a National Pollutant Discharge Elimination System Program permit, which you need for discharges into point sources and navigable waters like the Pacific Ocean. But they didn't need that because they injected groundwater, and the groundwater migrates to the Pacific Ocean. So this case was all about whether or not that discharging that pollutant into that groundwater that is hydrologically connected to surface water, if that could be encapsulated under the Clean Water Act. And the Supreme Court held that yes, it could. So not only now when there is a direct discharge into navigable waters, but when there is a functional equivalent of a direct discharge into waters. So the important piece there is that some groundwater may be regulated under the Clean Water Act through the NPDES system, and in Texas, the implementation is the Texas version. And there are some other types of permits that you have to get if you're applying wastewater in a different way through Texas, but here it would pull it into the Clean Water Act. But I think the important part here is that this functional equivalent test is not very well defined, and in fact, in the dissents and the opinions, some other justices said, how are we going to apply this? So I think it's going to look a lot like the significant nexus test looks like in a different aspect of the Clean Water Act. That came out of a 2006 Supreme Court case, and we've had EPA guidance and litigation, and all trying to define what a significant nexus is. So it looks like this is set up in the same manner, and we're going to need some more litigation and guidance to see how that actually is going to apply. And that's all. Thank you.
I gave these guys a really hard job, and they did an amazing, amazing job. I do, though, want to, and I didn't mention this to you, but we went really fast, and I know we're at the end of the conference, but I do want to give y'all, you've been sitting there now, if you went early, time thinking, what didn't I say? So I want to pass the mic around and give you guys just 1 minute, if there's like one closing thought or point in your presentation that you didn't get an opportunity to make that you want to leave with the group, let you do that before we wrap up for today. And Monique, why don't I start with you?
Hi. Okay. I still don't have the privilege of slowing down how I speak. I think one of the issues I didn't talk very much about Fazzino in that, and it was a little bit leaking into what I was saying about rules in Lost Pines, is that the issue of applying your rules prospectively, when that's what basically Brazos Valley did. They had existing wells, adopted the rules, the adoption date was the cutoff. You applied the new production acreage rules and spacing rules to new wells. That's what the equal protection summary judgment said. There are two distinct classes. It's rational basis. So I think that's really good for groundwater districts. About if you're at 2 acre feet and you're going down to 1 acre feet based on Chapter 36 and the hydrology, you apply those prospectively, you can do those. And you're acknowledging investment expectations, avoiding takings lawsuits, but then you are trying to limit damage as your authority to do under Chapter 36. So I think that's really important about prospective rules.
Yeah, so I guess the one thing that I didn't cover that I would like to have spent a little bit more time on is that, when talking about litigation, whether it's in state court or federal court, the best defense is going to be what you do before you get to court. The decisions that you're making every day on permits, the rules that you're enforcing, that you're treating people fairly, working with landowners, et cetera, those are the types of things that are going to keep you out of court, or when you get into court, equip you with a good defense. So that's what I have.
And I would just say, I think I covered most of it and may have covered this too, but just that Texas we have many aquifers. We have 9 big aquifers and 22 smaller and several river compacts. So the extent that the groundwater will be important in those compacts, what I wanted to make clear was that for Mississippi versus Tennessee, that is just a special master recommendation. So the Supreme Court can do whatever they want. They can adopt that or they cannot. So that really is something we still need to stay tuned on, and I wanted to make sure I didn't make it sound like it was, thrown out.
Thanks for giving more time.
I didn't mean to cut you off mid-sentence. I really
No, it's fine. And I said mostly what I wanted to say, but I think the key takeaway is that, you want to look back at your enforcement program. I mean, you have all the authority you need to kind of hold up your charge, protect the aquifer. But I think if you have a good enforcement program that kind of pulls in those pre-suit settlement options, I mean, it's a win-win in order to avoid some of these lengthy, costly battles, seeking those civil penalties. And watch out for Mountain Pure.
Thank you so much. Let's give this panel a round of applause.